Hi guys, I'm Izzy, a third year lawyer at the University of Cambridge, and when I was applying I also got offers from universities such as LSE, Warwick and Nottingham, and today I'm going to be showing you what it really means to critically engage with your supercurriculars by reading some of my old personal statement out. You've probably heard a lot of this idea of reflecting on your supercurriculars or critically engaging in them, but it's quite hard to know what that actually means without seeing it in practice. And I remember I found it really useful to hear other people talk through their personal statements so I can see how things were actually worded. Also, just reading it here, if I was doing the new personal statement, I would probably put this under question 2. So, inspired by learning the law of negligence and murder in A-levels, I explored these in a contemporary context by reading The Introduction to Medical Law by Charles Foster. I found it interesting to learn about resource allocation and whether it should be left to clinical or judicial determination. Courts are bound to only interfere if the authority acted irrationally, yet I find it irrational and unjust to deny treatment to a dying child because resources are being used up by a patient in PVS. Despite this, I cannot ignore that this would lead judges valuing one life over another, making it hard to find a satisfactory solution. So just starting on that and breaking down a bit what I did, I first kind of said where the interest came from, so in an A-level, and instantly linked it to something I'd explored outside of that. I gave a very brief, because I didn't want to be too descriptive, kind of explanation of what the debate was. So I was saying I was learning about resource allocation and who should it be left up to. So that's basically saying what happens if there's a limited amount of medicine and you've got to decide who to give it to. Hopefully it shows I haven't used basically much on describing it. I went straight into like, here are the problems and here's kind of what I think. So following on from that, I managed to link that book to another and said Foster mentions R and Brown, which I find intriguing, not only in questioning the defence of consent to bodily harm, but also the tensions between autonomy and society's interest. I found the judges overly paternalistic, with morality weighing too much in their judgment, as even if we personally find a behaviour repugnant, I argue this is not sufficient grounds to criminalise something. I haven't explained what the case is about because I'm presuming I don't need to waste time on that when the person reading it probably knows what that case is about. It's a very big one in criminal law. And again, I went straight into my opinion saying this is what I think of the judges, here are some of the issues with it, and here's what I argue instead. Like, just because people find something a bit strange doesn't mean we should criminalise it altogether. And then finally, I managed to link this to one other supercurricular. So I said, consequently, from reading The Enforcement of Morals by Lord Devlin, I acknowledge his ideas on intolerance. However, tolerance of lawmakers will differ to the upcoming generation. Does this make the state too dogmatic as they enforce their morals as truth? I am more partial to J.S. Mill's harm principle cemented by H.L.A. Hart, as I agree that the state should allow people freedom to pursue their own private morals. Again, notice I haven't explained what the book is about. I haven't explained what the harm principle is. Again, I went straight into like, this is what I